right, it's 2:10 p.m. already. Mr. Abra, can we start already? Judges? No.
All right, we should begin the round now.
You may begin now.
Hello, am I audible?
Oh, yes.
Okay. Hold on a minute. Okay. Wait, I haven't seen the other counsel of the respondent. Am I?
Here. Everyone is here already.
Oh, okay. Forgive me. My apologies. Good morning, Mr. President, Your Excellencies, may it please the court. My name is Muhammad Aksan Adiat Maamir, and I have the honor to appear on behalf of the Republic of Azura, the applicants in today's proceedings. I will speak for 16 minutes, while my co-agent, Mr. Nazal Amim Firdaus, will speak for 17 minutes. And with your permission, we reserve 2 minutes for rebuttal. Your Excellencies, over the course of the next 35 minutes, we will expound further on the first and second argument pertaining Republic of Azura acted in accordance with international law by launching military attacks against United Provinces of Roxana and need not pay reparation for the damage suffered. Meanwhile, my co-agent will explain the final submission. If Your Excellencies has no more preliminary inquiries, we will proceed with our first submission. Your Excellency, Republic of Azura action on using its military forces to exercise its right to self-defense under Article 51 of the UN Charter is in line with international law. In today's pleading, we submitted 2 major arguments. Firstly, Azura's action was in line with international law, and secondly, Azura has no obligation to pay for compensation. Entering our first major argument, we submitted that Azura actions is in line with international law for 2 reasons. First, Azura has a right for invoking preemptive self-defense. The military operation for protecting the African state national security under preemptive self-defense is justified under international law. The attacks were Azura's last resort on settling with Rosanna threatening the national and regional security and peace by possessing the hypersonic nuclear missile. If I may direct you to paragraph 13 of the Statement of Agreed Facts, Azura and other neighboring countries has initiated diplomatic approaches, and on Annex D, it is stated that after exhausting all diplomatic, this military action is the last resort for Azura. Your Excellency.
Sorry to interrupt, Counsel for applicant. May I just make sure that Mr. Abrar is in the room right now? Really apologize for interrupting. All right, okay. Sorry, Mr. Abrar, can I know if you're there?
Dia lucu ya. Masa Jackson tidak ada di dalam room?
Mr. Abrar, can I make sure that you are there?
Can't see you.
Oh, sorry, Mr. Ibrar, can you hear me?
You can hear him.
Mr. Ibrar, can I know if you are there? Sorry, participants. Allow us just a few moments.
Hello.
Yes, Mr. Ibrar.
Am I
are you
audible?
there? Yes, you are.
Okay.
So-
The thing is, I can perfectly hear you guys, but I am right now in my car, so that's why I have Bluetooth in my ears, so that's why there might be issue of voice. But otherwise, I can hear you guys perfectly fine.
I see. All right. I really apologize. I just had to make sure that you are there. So, first applicant, would you like to start from the beginning or take off from where you left off?
I would like to start from the beginning.
All right, sure. Mr. Ibrar, is that all right?
Yeah, completely fine.
All right, sure. So, first applicant, you may start your submission now.
Thank you so much, Aman. Good morning, Mr. President, Your Excellencies, may it please the court. My name is Muhammad Taksanadet Mamir, and I have the honor to appear on behalf of the Republic of Azura, the applicant in today's proceeding. I will speak for 16 minutes, while my co-agent, Mr. Nazal Amin Turda, will speak for 17 minutes. And with your permission, we'll reserve 2 minutes for rebuttal. Your Excellencies, over the course of the next 35 minutes, we will expound further on the first and second argument pertaining the Republic of Azura acted in accordance with international law by launching military attacks against the United Provinces of Roxana and need not pay reparation for the damage suffered. Meanwhile, my co-agent will explain the final submission. If Your Excellencies have no more preliminary inquiries, we will proceed with our first submission. Your Excellencies, the Republic of Azura action on using its military forces to exercise its right to self-defense under international law is justified. In today's proceeding, we submit two major arguments. Firstly, Azura actions was in line with international law. Secondly, Azura has no obligation to compensate. Your Excellencies, entering our first major argument, we submitted that Azura action is in line with international law for two reasons. First, Azura has a right for invoking preemptive self-defense. The military operations for protecting the African state's national security under preemptive self-defense is justified under international law. The attacks were Azura's last resort on settling with Roxana, threatening the national and regional security and peace by possessing the hypersonic nuclear missile. In paragraph 13 of the
Excuse
statement,
me, sorry for interruption.
yes,
I can like hear your voice very heavy, like it's not very clear to me.
forgive me. Hello.
Hello.
Hello?
Yes,
Am
I
I,
hear you, but your voice is very heavy, like it's not very clear. I don't know, it's a problem with your mic or your laptop, but there is something wrong.
okay. May I have a second to fix my audio?
Yeah, if you could kindly connect through other device, that would be great, I guess.
Would it be a good idea to stop the time right now?
Hello, am I?
Yes, I can hear you now.
Thank you so much, Your Excellency.
Please proceed.
The attacks were Azura's last resort on settling with Roxana's, threatening the national and regional security and peace by possessing the hypersonic nuclear missile. In paragraph 13 of the Statement of Agreed Facts, Azura and other neighboring countries has initiated the diplomatic approaches, and on Annex D, it is stated that after exhausting all diplomatic approaches, this military action is a last resort for Azura. Your Excellencies, the attacks were in line with international humanitarian.
Council,
Yes, Your Excellency.
you have mentioned that it was a last resort. So is, trying to have conversation diplomatic is sufficient? Is it
Yes, Your
like the
Excellency.
only resort, only option with which you can avail before launching an attack and then, taking such a hostile step?
It is one of the way to
Yes,
to
one
have a.
of the ways. But what are the other options that you could have availed? Why is it last resort? Because violence is a very last resort where there is a do and die situation. So why didn't you guys like avail? Why didn't the Azura state avail other opportunities or options before going for this step?
Yes, Your Excellencies. It is because having to diplomatic approaches with the respondent state is one of the only way to have this to have this meeting so that the threat that was possessed from the respondent state is the only way to prevent and settle this and to settle this dispute.
Okay, Council, did Azura approach the United Nations, for that matter, United Nations Security Council,
I'm
before
sorry.
launching an attack? Did Azura state approach United States Security Council?
I'm sorry, Your Excellency, I cannot hear your voice very clearly. Can you repeat it, please?
Can you hear now?
Yes, Your Excellency.
So my question is that did Azura state approach United Nations Security Council before taking such steps?
Yes, Your Excellencies. It is. Yes, it is, Your Excellency.
So no, before invoking the self-defense provision, as you have said, Article 51, that the same provision requires that first the request should be made to the United Nations Security Council that we are going to take such a measure. So that has happened or not?
I'm sorry, Your Excellency, I cannot hear you very clearly.
Can everybody hear me?
Unfortunately, you are breaking out a little bit.
I don't know why. Just one second. Now, am I audible?
Yes, you are.
Yes, you are.
Okay, so my question is that before launching such an attack, the preemptive self-defense, did Azura state, resort to United Nations Security Council, and whether they, get the permission for that or not?
Yes, indeed. The the approaches to the attack was indeed before before the engaging of UNSC. But however, Your Excellencies, if I may refer you to article, wait, uh, may I have a second to conclude my answer?
Yes, please.
Thank you so much. Okay. If I may refer you to Article 33, it is stated that any the parties to any dispute, the continuance of which likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, and so on and so on and so on. And it is part of the diplomatic approaches, Your Excellency. The so so the diplomatic approach of the Republic of Azura is already is already the the settlement the effort of a settlement of disputes by the Azura
But
state.
counsel, all the options that you have stated, mediation, conciliation, those were not adopted, and the diplomatic, talks cannot be tantamount to those modes of dispute resolution.
Yes, Your Excellency, but it is also mentioned that in the same article, it is said that other peaceful means of their own choice. So a diplomatic approach is count as a settlement of disputes.
Counsel, my what I'm trying to say that it is definitely one of the modes of resolving disputes, but it is not only the means, because only one step has taken place by Azura. But what about the rest of the modes? If you are saying that it is the last resort, then why not to exhaust other remedies before going such a far way and take such a hostile step?
Yes, Your Excellency. Yes, indeed, that other remedies was supposed to be engaged by the Republic of Azura before launching its attack. However, there was already several of diplomatic approaches. There were several of approaches conducted by not only Azura but also the other international organization or uh, international other countries that that the that the that Roxana need to open for transparency, Your Excellency. So it is count as a last resort because it is already an exhaust of all of the of all of the
Counsel,
efforts.
counsel, please, it's a court of law. Don't make mockery of it. Like you are negating your own argument in that way. If you are asserting that yes, they should have taken such steps, but on the other side, you are saying that one can evade that, but only diplomatic steps have been. No, just be very clear cut. What does the law says? Argue on that.
I'm sorry, Your
Please
Excellency.
proceed.
Can I have a moment to conclude my answer?
Yeah, sure. If you do not have like a second main argument, you can proceed, please.
Okay, thank you so much. Your Excellencies, can I have a simplified question of your question?
Yes. Sorry.
Can you give me a simplify? Can you simplify your question for me,
Okay.
please?
Okay. All right. What does UN Charter says? It says that first you have to take certain steps before invoking the right to self-defense and before taking launching an attack. If there is no response from the other state, if but they are perpetuating the continuous imminent threat to you, that way only you can invoke the right to self-defense. And that is also not very generalized. You have to establish it. You have to establish imminent threat, and there are certain essential elements of imminent threat as well. And that is, I'm just giving an example. The imminent threat could be established in a way that the acts of the another state or their talks have established that they are going to launch an attack against your state, and that way imminent threat could be established. But there is no such fact in the statement of facts.
I'm so sorry, Your Excellencies, I cannot provide you with the answer at the moment.
Yes, please proceed with another argument.
Thank you so much, Your Excellency. Uh, Your Excellencies, the attacks were in line with international humanitarian law for its accordance with the principle of proportionality and the principle of necessity. It is stated in under Article 51, paragraph 5, point B of the Additional Protocol 1 of Geneva Convention. It is stated that an attack could be proportionate if the attacks are military objectives. And under Article 52, paragraph 2 of the Additional Protocol 1, it is stated that military objectives are limited to those objects which by their nature, location, purpose, or use make an effective contribution to the military action and has and offers a definite advantage. In line with international law, since the direct military target has military advantage to the applicant state. The attacks also were in line.
Counsel?
Yes, Your Excellency.
Counsel, don't you think that it was quite disproportionate? Because for proportionality, there must be the same gravity act by another state.
I'm sorry, Your Excellency. Can you please repeat your question?
Yes, I'm saying that isn't it a too disproportionate step? Because for proportionality principle envisage there should be the hostile act of same gravity which have been perpetrated by another state. But here there is a self-defense. There is no question of proportionality because someone has not directly attacked you directly, but you have taken a preemptive step.
Yes, Your Excellency. We do aware that the attack that Roxana does not attack does not attack that does not attack the Republic of Azura. But however, Your Excellencies, it in the resolution of in the UNSC resolution 47/95K, it is regarding the nuclear weapons by the South Africa. It is the nuclear weapon program was cancelled because because the developing of nuclear weapons is a threat to international region and security. So here then the preemptive self-defense.
Counsel,
Yes, Your Excellency.
in any state for that matter, because the nuclear state, if we assume that nuclear missiles are dangerous to all the humanity regardless of the borders, right? Can any state invoke self-defense?
Yes, Your Excellency.
Okay, like any state can invoke. Great. Please proceed.
Thank you so much, Your Excellency. Entering our second sub-argument, Roxana possession of the hypersonic nuclear missile is not in line with international law. It is because Roxana breached its obligation under customary law, a customary international law. The state obligations on nuclear disarmament is located in the Non-Proliferation Treaty, Article 6. And these states' obligations are applicable since, firstly, this obligation was a result of a widespread state practice. For example, uh, in South Africa, before signing to the Non-Proliferation Treaty, they ended their nuclear program to negotiate its way to nuclear disarmament. Your Excellencies, I've seen that my time has elapsed. Can I have additional minutes to conclude my argument?
Council, you have 30 seconds to wrap up your argument.
Okay, thank you so much, Your Excellency. Here, the the possession of the nuclear weapon is a violation because a violation under customary international law, because it is not in line with the Article 6 of the NPT on doing on Article 6 of the NPT, and it is also stated mentioned in the UNSC and it is also from a widespread state practice, such as South Africa and Ukraine, when they possess the world largest nuclear weapons. And my last major argument, it is that Azura is violating the conducting international wrongful act, and hereby Article 36 of the Article 36 of RCWA obligates Roxana, obligates Azura to not to pay for compensate, since they did not any wrongful acts. And however, if the court find the applicant conduct an international wrongful act, in Article 21 of RCWA stated that the wrongfulness of an act of a state is precluded if.
Council, thank
Yes,
you. I
yes.
guess your time has, lapsed. So thank you.
Thank you so much, Your Excellency. If this court has no more inquiries, may it please the court.
Your Excellency, am I audible?
Yes, you are.
Okay. Good afternoon, Mr. President, Your Excellency. My name is Nazalami Firdaus, and I'm the co-agent appearing on behalf of the Republic of Azura as the applicants in the current proceeding. As introduced by the first agents, I will be dealing with the last submissions in the next 17 minutes. I have the honor to address applicants' final submissions concerning United Provinces of Sana violated international law interrogating Octagon with its hypersonic nuclear missile and must pay reparations to Republic of Azura for the damage suffered. If this court has no preliminary inquiries, we would like to continue with the applicant submissions. Mr. President, Your Excellency, may it please the court. On 29 October 2022, the United Provinces of Roxana found that the constant dispute with the Republic of Azura would put them on the brink of the collapse. Thus, they deployed their nuclear missile with the concern to raise the grave consequences to the Republic of Azura. This attack caused the severe casualties, destroyed the critical facilities, threat, and give constant trauma to the civilians. As its result, targeting Octagon with its hypersonic nuclear missile. Second, Roxana entitled by reparations measure for injury occurred. Your Excellency, moving to the first claim. The Octagon, the United Provinces of Roxana violated international law in targeting Octagon with its hypersonic nuclear missiles. There are three thresholds to in proving that. First, it is violating the charter. Second, it is violating international humanitarian law. And the last, Roxana also violate the human rights law. Moving to the first sub-argumentations, that respondent violated the charter. There are two analyses. First, they are violated the principle non-use of force. Under the Article 2, Paragraph 4 of the Charter, the state must refrain themselves to using force against the other state territorial integrity. To determine the justifications for the use of force through the Nicaragua case, the judge exercised that the use of force as a part of self-defense must be first proportional, be necessary. Referring to this proceeding, Roxana has no proportionality in using its force for attacking Azura, proven by the causalities left by the attack was severely excessive. In addition, the attack is not necessary because the launch of nuclear weapon conducted by Roxana is not the only way to resolve the dispute or last resort. Thus, the principle non-use. Yes.
But the Azura state has, attacked on all the important and key buildings of their military operations. So only option they had was to launch such missile because all of the, key and essential and important buildings had been destroyed by Azura state. So what options did they have, and what is now necessary? Uh, like for me, it looks that they had this necessity to attack because there was no option available to them.
Your Excellency, even though the attack conducted by Roxana is targeting Octagon as our military objective, but we have to notice, but the effect is very excessive. They are killing millions of people. They are make our transportation path become more severe. Many of our doctor or health worker are very struggling and resolving this dispute itself. So we say that the attack conducted by Roxana is not giving him any military advantage as a one of the threshold. If you would say that your attack is directly to the military objective, while when they are launching this missile, the nuclear effect very excessive, and there is no like concrete military advantage that they gain. While in other part, our civilian become more suffer. They are struggling, and this is unequal and unproportionate with the military advantage that they get. So I hope it satisfied you. Second reason, Roxana's actions cannot be justified as a self-defense. Yes.
Don't you think the part of the problem is Azura state itself? Because they should have thought before launching an attack, before attacking every essential building of military, personals. And they should have thought about this avenue that while they are attacking everything, the only option Rexona would have is to launch the hypersonic missile.
Your Excellency, in fact, at very first place, Roxana did not show any good faith in diplomacy process itself. If I may refer you into the paragraph 10 on the Moot problem case, it show on how Roxana is not cooperatively active in the social media discourse. They are trying to dismiss the discourse. They are trying to oversharing the discourse itself. It showed that the process of diplomacy is not run that well, and that's the reasons of why our earlier strike is a part of our self-defense, because it is the clear imminent threat of
Counsel,
self.
you yourself cited the case of Nicaragua. The self-defense should be, launched in light of proportionality and in light of necessity. So, do you think that was, a proportion that was, necessary? If they were reluctant to, to have these talks diplomatically, you should have attacked only one or two or three military bases. You have destroyed them entirely.
Your Excellency, their uncooperativeness in social media discourse is not the only reason for us to launching our military troops for their military objective. Far from that, we say that it is very clear imminent threat for our state because we are directly too near from this their state. Secondly, if I may address you to the Moot problem itself, it is stated on how Roxana also conducts several testing mechanism on their nuclear missile itself. It is indeed affecting our ecological stability, and it is for further. We don't think so that it is needed for this state to developing this. Another next generations of weapon, because they are at very first place as a very known as a country who has strongest army, right? So it is questionable if they are would like on again to developing itself. It is can be stipulated
Has the
and can be
Azura
interpreted
states
as the threat to our country. Yes, your
Council?
excellency. Yes.
Has the Azura state sovereignty been infringed by the Rexona?
Can you repeat your questions, please?
Has Azura's state sovereignty been infringed by Rexona?
Yes, we are involving in this course of social media addressed to paragraph 10 of the Moot problems. Secondly, we also already addressed our statement through Annex B on how we are needs the transparency from the Roxana itself on the process of the development of nuclear missiles itself. But in fact, Roxana cannot give it a clear transparency on the development of their nuclear missiles itself. Your Excellency, moving to second reasoning why it is unjustifiable. Roxana actions cannot be justified as a self-defense. The use of force as a part of self-defense, which is acknowledged under the Charter. However, this is subject to the principle of proportionality and necessity. In the present case, Roxana attack does not fulfill the principle that is because Roxana is unable to targeting attack concrete and directly to the for resulting in military advantage. Also, it is not necessary because Roxana's attack was not immediate response to ongoing strike, and there is another realistic measures in achieving accusations of the attack itself. In sum up, Roxana's action should not be justified as a self-defense. Second sub-argumentations, respondent violated the international humanitarian law by using its hypersonic nuclear missiles. Under this proceeding, we have three reasons. First, Octagon is not a military objective. Second, the hypersonic nuclear missiles is an indiscriminate weapon, which leads to indiscriminate attack. And the last is the respondent violate its responsibility to maintain peace and order. First reason, Octagon is not a military objective. Under the IHL, an object must fulfill two elements. First, have effective contribution. Second, and can give military advantage. In the present case, the attack targeting the Octagon does not give a military advantage, where the military advantage should be concrete and definitive on the military objective itself. However, in the present case, the attack is not proportionate and unnecessary since the causal and that collateral damage itself. In addition, in NATO bombing case, it is considered the need to avoid targeting the military advantage if there is likelihood of the collateral damage of causing long-term damage. So that is the reasons of why it is can be also cannot be justified as a self-defense, because their attack is very likely to give collateral damage to our civilian populations. Another reason, the attack using hypersonic nuclear missile is an indiscriminate attack. Under customary international humanitarian law, the usage of weapons that are naturally indiscriminate is prohibited. Indiscriminate weapon could be referred to those weapons which cannot be redirected at military advantage or whose effect cannot be limited as required by international humanitarian law. Furthermore, these nuclear missiles can cause horrible effect massive destructions, and huge losses of the civilians. Thus, the launch of hypersonic nuclear missile leads to unnecessary suffering. However, this is something that contrary with the international humanitarian law, which stated that the use of means and method of warfare, which are of a nature to cause superfluous injury or necessary suffering, is prohibited. The last reason, the hypersonic missiles is a weapon, massive destructive, which contradict with an principle of distinctions. As I said before, that their nuclear missiles can be constituted as a indiscriminate weapon, so it is unjustifiable under international humanitarian law. Even though Roxana's nuclear missile used expectedly target against military objective, but the nuclear missile in very nature means after being launched, their effect escape from the control of the launcher, or we can say that it is uncontrollable, and may strike both combatants and civilians, and necessarily excessively create a risk and to the civilians' causalities. This would put the civilians in danger situations. That's the reasons why this is prohibited under the international humanitarian law. Third sub-argumentations. Roxana violated the human rights law. Two reasons. The launch of hypersonic nuclear missiles by Roxana violated the highest attainable standard of living under ICESCR. The usage of nuclear weapons would inflict such damage to the natural environment as to violate the right of people to live in healthful and ecological balanced environment. In the present case, the launch of Roxana's nuclear missile contradict within this idea, which is the right of highest attainability in living. Second reason, in these argumentations on how Roxana violate this human right law, because addressing Octagon by the hypersonic nuclear missile proved the adequate infringement of right to live. Under ICCPR, it's clearly declared that each human being has the infringement right to live. Considering massive damage and an undistinguished attack occur as the result of hypersonic nuclear missile launch, it indeed raises the infringement of right to live. In addition, targeting Octagon, which locations in heart of the city, place of millions of civilians who live, would have more severe attack of evac in that region. Under that reason, it has proved that addressing Octagon is unlawful under international law. Moving on to the second main argumentations. Roxana, entitled by reparations measures for the injury occurred. There are three analyses here. The first one, Roxana's attack is constitutes as international wrongful act. There are two thresholds in considering an act as international wrongful act. The first, it is attributable under the state. Second, there is a breach of international obligations. First threshold, attributions could be referred as a subject in common legal practices terminology. In addition, attributions must be under a state which is constitutes as an organization's entity and a person's with authority to act under international law. Thus, Roxana actions is attributable under the state. Second reason, there is a breach of international obligations conducted by Roxana. It is also proof that it is part of international wrongful act. Referring to the previous argument, we already proved that Roxana's attack by using hypersonic missiles is not in accordance with the fundamental state obligations such as the purpose of United Nations under the Charter to maintain peace and order. Targeting an attack to the non-military advantage indiscriminately and in accordance to the principle of distinctions in attack which regulated under the international humanitarian law and fundamental human right laws such as right to have highest attainable standard of living and right to live. These arguments has been stated in our first main argumentations. Second sub-argumentations, Azura is an injurious state. Your Excellency, we have to know that injurious state could be implicitly defined as a state who suffered from any damage caused by other state which acted in accordance to the international wrongful act. In the present case, Azura is affected by Roxana nuclear missile launch. Not only direct, the effect is not direct and concrete to our military objective. It's far from that. They are also excessively attack, killing, and give a destructive effect to our civilians. So that's reason so why it is unjustifiable and we are entitled as I enjoy staying here. I saw my time is almost elapsed, but if Your Excellency can give me 1 minute more to conclude my argumentations, I would be more than happy to conclude my argumentations accordingly. Your Excellency.
Hello, am I audible?
Yes, you are the boss.
I'm so sorry. I was just having internet connectivity issue, but please proceed.
Thank you so much. Third reasons on the explanations why Roxana entitled by the reparations measure, because Roxana has responsibility to pay reparations for the Azura. Under the Article 34 of RCWA, the restitutions for the injured state could be in form of restitutions, compensations, and satisfactions. However, in this proceeding, the applicants filed the lawsuit for demand of first, restitutions, and second, compensations. First, justifications on our restitutions. Restitutions aims to restoring the object closely with the previous damage in this case. The attack of Roxana affects very damaged losses such as building destructions, transportation accessibility, and etc. Thus, Roxana must pay for the restitutions to building up and restore the damage occurred conducted by their self. Second reason why it is justifiable to ask for the compensations. Under the Article 36 of our CWA, compensations is paid by responsible state for the material damage. In this case, Roxana must pay for the compensations based on the financially calculated suffering. To conclude our submissions, here we submit that Roxana violated international law by targeting Octagon with its supersonic missile and must pay reparations to Republic of Azura for the damage suffered. Thank you, Your Excellency, Mr. President. May it please the court. Thank you.
Shall we proceed to the next speaker, the respondent?
Excuse me, may I proceed as the respondent? Okay, thank you. Good afternoon, Mr. President, Your Excellencies, may it please the court. My name is Afiq Ahmad Hanif, and I have the honor to appear on behalf of the Republic of Roxana, the respondent in today's proceedings. I will speak for 16 minutes, and my co-agent, Ms. Johanna, will speak for 17 minutes. And with your permission, we reserve 2 minutes for sure rebuttal. Your Excellency, over the course of the next 16 minutes, I will be submitting that 1. Republic of Azura violated international law by launching military attack against United Provinces of Roxana and must pay reparations for the damage suffered. And my co-agent will be submitting regarding our second submission that United Provinces of Roxana acted in accordance with international law in targeting Octagon with its hypersonic nuclear missile and need not pay reparation to Republic of Azura for the damage suffered. If this court doesn't have a preliminary inquiry, may I proceed to my first submission? The military attack conducted by Republic of Azura occurred in the provinces of Roxana territory on 15 October 2022 and constituted a breach of international law under the Charter and Principle of International Law. Your Excellency, entering our major submission, we submit that, firstly, Azura military attack violates international law by launching an attack towards Roxana. Secondly, Azura is obligated to compensate Roxana for the impacts. Your Excellency, in the first argument, we submit that Azura committed an aggression. Secondly, In any event, international law does not recognize preemptive self-defense. And lastly, the possession of nuclear weapons is not prohibited under international law. Answering our first argument that Azura committed an act of aggression. The attack conducted by Azura is an act of aggression, whereas under customary international law, the threshold for this action has stated explicitly. To fulfill the requirements of an act of aggression, Azura has breached the principle of non-use of force and violates the sovereignty of another territory. Moving to our sub-argument, we submit that Azura has breached the principle of non-use of force. The attack launched by Azura on Roxana's territory is a clear violation of Article 2, Paragraph 4 of the United Nations Charter regarding the prohibition of the use of force against another state territory. Moreover, the prohibition of non-use of force is also recognized as a preemptory norm and customary international law. Republic of Azura launched a conventional attack against United Provinces of Roxana, utilizing its land, air, and naval forces in a coordinated assault. Thus, the attack was a breach of Roxana's territorial integrity and the principle of non-use of force. Our second sub-argument, we submit that Azura's military attack violates the sovereignty of Roxana. The concept of sovereignty comprises the possession of supreme authority of a state, including the power of regulating its international affairs without foreign dictation. The decision of an ICJ on the Corfu Channel case emphasizes that the United Provinces of Roxana's Ministry of Foreign Affairs that the attack was a blatant violation of international law and their sovereignty. Based on Article 2, Paragraph 4 of the United Nations Charter, it is clear that the breach of a state's territorial integrity is a violation of sovereignty. Second, in any event, international law does not recognize preemptive self-defense. Under international law, preemptive self-defense is not recognized since Article 51 of the United Nations Charter only recognized individual or collective self-defense. But in the present case, Republic of Azura launched the attack under the doctrine of preemptive self-defense. Republic of Azura launched the attack under doctrine of preemptive self-defense, which has never been explicitly regulated in the Charter. Furthermore, Republic of Azura didn't fulfill the requirements of self-defense. Here we submitted our sub-argument that the military attack is not proportionate, and then secondly, the attack is not necessary. The attack launched by Republic of Azura is not proportionate since there was a loss of civilian life and the well-being of United Provinces of Roxana's citizens. It is stated in Article 51 of Geneva Convention Additional Protocol 1 that civilians must be kept away from the danger of military operations. Thus, the attack violated international law and didn't fulfill the proportionate requirement. Our second sub-argument that the military attack is not necessary since there is no armed attack prior. In the Nicaragua case, the requirement of necessity is well established that only if an armed attack occurs is it necessary to respond to it. Hence, the military attack launched by Republic of Azura is unnecessary. And the third, the possession of nuclear weapons is not prohibited under international law. The hypersonic nuclear missile under the possession of United Provinces of Roxana is not a violation of international law, since the Lotus Principle allows for states to exercise their jurisdiction and their sovereignty if there is no explicit international legal framework that prohibits to do so. The legality of nuclear weapons is also stated in the advisory opinion of legality of the threat or use of nuclear weapons, where there is no universal prohibition of the threat or use of nuclear weapons as such. Thus, absent such prohibitory rule, states have the right to use nuclear weapons. Move to our last major argument that Azura is obligated to compensate Roxana for the impacts. It was described that the military attack carried out by Azura, resulting in widespread devastation and loss of life throughout the United Provinces of Roxana, is a breach of international law. Regarding this problem, the obligation the obligation of reparation is formulated in Article 31 of RCWA as the immediate corollary of a state's responsibility. The obligation to make full reparation is the general obligation of the responsible state consequent upon the commission of an internationally wrongful act. Under this reason, Roxana respectfully asked the court to declare that Azura is entitled to obtain compensation for all the damages caused by Azura. To conclude our argument that Azura's military attack against Roxana has breached the international law, which resulted in infrastructure destructions and loss of life. Azura's claim for a self-defense is unlawful since there is no armed attack occurred before. Therefore, Azura must pay the reparation for the damages. Unless Your Excellency have future questions, this concluded our argument. May it please the court.
Mr. Ibra, are you there?
Dear participants, Mr. Ibrar is currently facing some technical issues. So we will move you to the, I'll get back to you. So allow us a few moments to get Mr. Ibrar to join the meeting room. And after he has joined, we can proceed to the second respondent. Mr. Ibra, can I know if you can hear me? Your Excellency, if you need any technical help, please do let us know. Really sorry for the inconvenience, participants, but we are still trying to contact Mr. Ibrar. I believe it's due to the internet connection that we are unable to reach him currently. Hello, participants. So it seems that Mr. Ibra can't join us today. So we have contacted another judge who can come in to take over Mr. Ibra. Would it be okay? I would like to ask you, would it be okay if the appellates and the respondents redo their submissions from the beginning? Or would you prefer for us to wait for Mr. Ibra to come in?
Your Excellency, I want to ask how about the applicants too, whether the judge already hear it well or not.
Yes, we are worried about that as well. So, um, would it be okay if we begin the round from the very beginning, meaning starting from the first applicant? I understand that this might be of inconvenience to you. However, we are currently unable to reach Mr. Ibra. So, if I could get you guys to agree to start from the beginning, we shall proceed with a different judge. If not, we can continue to wait for Mr. Ibra to come in.
Excuse me, committee.
Yes.
We're from the respondent team. We okay if we started from the very first beginning with the judge, but if we may ask for 15 to a half an hour before we can redo the round again, since we have to do our prayer here, if it's okay.
All right. So, can I get the applicants to agree as well? Shall we take a 15 to 30 minutes?
Yes, we do.
All right. So, I really apologize. This was very unforeseeable. We didn't think that this would happen, and we will do our best to proceed with the next round. So I shall see you here at 4 p.m. Malaysian time, which is around
It is the same with our time zone.
all right. So I shall see you at 7. Thank you very much, applicant and respondent.
Thank you very much. Comment.